Mr. Sheffalo, are you able to hear me okay?
Loud and clear, Your Honor. Good morning.
Okay, great. And does that look like your client there?
That is Mr. Sharkowski. Yes, Your Honor.
Okay, great. So we'll go on the record now. This is Sharkowski versus Secretary of State, file number 2514900. If I could just have counsel put your appearances on.
Your Honor, Ryan Ziegler on behalf of the AFL Secretary of State.
Good morning again, Your Honor. Gerald Sheffalo appearing on behalf of Mr. Stephen Sharkowski.
Okay, and the record should reflect Mr. Sharkowski is also present by Zoom today. So this is set for oral argument. Mr. Sheffalo, you filed an appeal of Secretary of State denial of a license for Mr. Sharkowski. I did have an opportunity, Mr. Sheffalo, to go through your filing, including all the attachments and the attached case law, specifically given the nature of the review in this case. Of course, the transcript of the hearing before the hearing officer, I did read through that carefully, as well as the hearing officer's decision. And so today is the opportunity for oral argument. So Mr. Sheffalo, anything that you wanted to present today in support of your position?
Thank you, Your Honor. Yeah, just relying on what I've already submitted, but also just to add a few points to this case. I was the original attorney on this case in Kalkaska County. I've known Mr. Sharkowski for that long. And I really felt that in this case, we have laid out that for whatever reason, the hearings officer started to focus on a discrepancy or a misunderstanding of the length of sobriety. It's only required to be 1 year that we had to demonstrate. And whether it's 2008 or 2009, I don't know if something went wrong in the hearing that we made it clear that Mr. Sharkowski, he was convicted of negligent homicide at the time, a high court misdemeanor, 2 year maximum, and he served a prison sentence on that. I felt at the hearing that we had some definite demarcation of even taking the last possible date of use, that it was clear. And the hearings officer instead felt that there was some kind of credibility issue with Mr. Sharkowski. I felt that the questions got a little confusing in the hearing. I felt that the assessor, Preston Green, made it very clear of where Mr. Sharkowski was in his life and his prognosis of excellent to be chemical free. Mr. Sharkowski, we have the paperwork from his doctor. Everything that he currently does with his medical treatment was disclosed to his doctors. That was presented to the hearings officer as well. And I don't want to speculate about what a hearing officer typically sees, but I do a number of these hearings. I've never done a hearing where the individual that I'm representing does not have multiple offenses. This is just not a typical case that comes before a hearings officer, because there is one conviction that's led to the license being revoked. And at the time, well, we don't have the neg anymore, but at the time, none of the elements of negligent homicide required the prosecutor to prove any type of substance use at all. It wasn't part of the neg ham statute. So this case is so different that one conviction many years ago, a prison sentence, there's not the repetitive signs of use. That's the other thing that I think the hearings officer overlooked. Typically, people that are struggling with addiction, they have more offenses, whether it's possession, whether it's another driving incident. They when they haven't got their habits and their addiction's under control, they surface somewhere in some form, even some other type of case, maybe domestic violence, something like that. We don't have any of that here. I have kept in contact with Mr. Sharkowski, and I know what prison did to him, and I know how much it changed him and his opinion of life in general. And he's not a risk taker. So we had no pattern of convictions. We have no continued pattern or evidence of abuse. We have positive letters from people that know and support him. We have Mr. Green, who doesn't know him, who is the assessor and knew all of the information and felt that the prognosis was excellent. And I just feel that use of a possible discrepancy in dates leading to the conclusion that Mr. Sharkowski has no credibility, that his letters have no credibility, that Preston Green has no credibility. I think the hearings officer has made a mistake in this matter. I think they've abused their authority and discretion, Your Honor. And I just would say that this argument, coupled with everything else that the court has reviewed, and I know Mr. Ziegler is very diligent. He's reviewed this as well. He has the same binder. I think we have a matching. We all have the same binder. So I would rely on that and ask if the court has any questions, Your Honor.
I don't have any questions at this time, Mr. Sheffalo. Mr. Ziegler, did the people file any kind of brief on this?
No, you're
okay. So I'm not aware of what your position is or Secretary of State's position. So I'm interested in hearing that before I have any questions for Mr. Sheffalo.
Your Honor, I've spent a lot of time in this court doing trials, doing hearings where I'm told that I need to meet a burden of proof. And so I'm very happy today that the shoe is on the other foot, where I have to insist that the appellant meets their burden of proof in this case. And I simply don't think they can do that. The burden of proof at the hearing was clear and convincing evidence that the substance abuse issue has been mitigated or is under control. The hearings officer took testimony, reviewed the letters, and there were discrepancies, not just one discrepancy, not just a clerical error, but multiple discrepancies, both about the date on which Mr. Sharkowski stopped using alcohol. There were 2 different dates given for that, maybe 6 or 7 months apart. There were also different dates given for when he stopped using methamphetamine, and particularly the dates regarding the methamphetamine are notable to me, and I believe were notable to the hearings officer, because one of those dates was before the accident, and one of those dates was after the accident. And to me, and presumably to the hearings officer, that's an important distinction. I think it would have been very clear in the petitioner's mind whether he had stopped using methamphetamine before the accident or whether he'd stopped using methamphetamine after the accident, and presumably because of the accident. And so those discrepancies, I agree with Mr. Sheffalo that if it's just a question of it must be one of these 2 dates and we're just arguing over which date it is, clearly there's more than a year of sobriety there. But I don't think that's what the hearing officer is saying. I think what the hearings officer is saying is that because there's these discrepancies in multiple different questions about the term of sobriety, it calls into question whether not just that the date is accurate, but that there's credibility as to the statements that this has been something that Mr. Sharkowski has committed to, something that he knows exactly when this occurred and how long it's been going on. It calls into question the veracity of his testimony. And the standard at that hearing is clear and convincing evidence. The standard at this hearing is a arbitrary or capricious decision. And I don't think that the hearings officer presented with that testimony, I don't think it's arbitrary or capricious for him to say, I don't have enough here to be convinced that this person knows when his sobriety began, knows what his term of sobriety is, and he's not continuing to use because the testimony is so inconsistent. So I would just ask the court to hold the appellant in this case to their burden of proof. I don't think that decision was arbitrary, capricious, or an error of law.
All All right, thank you. Mr. Shefflow, anything that you wanted to say in response?
I understand what Mr. Ziegler's saying. I, I would agree with a lot of what he had to say. However, the biggest issue is the time between the original offense and the prison sentence. If this was an issue of, well, we're not sure because it could have been 2023 or maybe 2024, and Mr. Sharkowski, I don't know if you've demonstrated 12 months of abstinence to the hearings officer's satisfaction, that would be a different story. We have a case from 2009. This isn't a recent case, and the hearings officer, even with this credibility issue, then overlooked the letters. We present the letters in lieu of testimony at the hearings. She overlooked all of the letters that would indicate the sobriety, the people that see him, the people that know him. Again, overlooked what the substance assessor had to say and expanded our burden of proof, expanded the requirement far beyond 12 months. Um, and I do understand that it's important in those cases and those hearings to have consistent testimony, but it becomes more relevant when the appeal is done in 2011 or 12, for example, and it becomes less relevant and less important. And that's why I feel that the hearings officer lost their way in this case by the amount of years well and above 12 months, Your Honor. But I do understand what Minister Ziegler's saying. I do agree with a lot of the way he looks at the case as well. But this case is just one of those cases that's very different without the repetitive convictions, without the issues with other types of drug or alcohol cases not related to driving. It's a different fact pattern, and the length of time has been demonstrated by Mr. Sharkowski, and it was only 12 months that we needed to demonstrate, and I believe we did that with our letters, and I believe we did that with our assessor's report, and we did that with his own testimony. There's no testimony there to say that he had any issues or relapses anywhere close to recent memory. So that's where I think the hearings officer is wrong in this case, Your Honor. I ask that you overturn this decision.
Okay, all right. Now that I've been able to hear kind of argument from both sides, I'm going to take just about 10 minutes. I want to review a couple things based on what Mr. Ziegler and you have had to say here, Mr. Shefflow. And then I'll come back on the record, like I said, 10, maybe 15 minutes tops with the court's ruling. So Mr. Shefflow, I'm just going to put you and Mr. Sharkowski back in the waiting room, and I'll bring you back in just a few minutes.
Thank you, Your Honor. Thank you, Mr. Ziegler.
Do you want me to just have Christy let you know when we're ready, or are you going to wait here?
talk to you.
Okay, we've got everybody back connected. Thanks for your patience. Again, there were a couple things raised there that I wanted to just go over real quick based on the record. So as I indicated at the beginning of the hearing today, I did have a chance to review, I'm just going to refer to Mr. Sharkowski as the petitioner here. The petitioner's brief argument, the law that was cited, the unpublished cases that were attached. Of course, again, I reviewed the transcript of the hearing, the decision of the hearing officer, and all the exhibits that were attached that were admitted at the hearing as well. In addition to that, of course, I've heard the arguments of counsel here on the record today. So I feel that I'm well-versed in the facts of this case, the applicable law, and the court standard of review. The first thing I want to say, in reading through the transcript, and in particular, Mr. Shefflow's brief, it's very apparent to me that Mr. Sharkowski is very remorseful for what happened in this case. I think it's one of those things that if he could take it back, he certainly would. I got that impression from his testimony very clearly. I think it has affected his life dramatically over the 15, 16, 17 years since it occurred. Certainly, from a legal standpoint, he paid his debt to society. He was convicted, he served his time. He was successfully discharged from parole. So, and none of those things necessarily relate to the issue that we have here today, which is whether or not he should be granted driving privileges. But I do think those things are all relevant when the court looks at the overall circumstances of the case. And I think it's important to acknowledge that as well. And that's not to say, of course, that the victim in this case and the victim's family and friends weren't greatly affected and that they haven't continued to experience the effects of that over the intervening years. And I'm sure that it still affects them and their lives today as well. So this is unfortunately the kind of incident that changed everybody's life that was involved in it in a negative way. And that's unfortunate. Looking at the issue that we have here today, the court standard of review, as acknowledged by the parties, the court reviews a hearing officer's decisions of law de novo, decisions based on facts and application of law to the facts is an abuse of discretion standard. The court is reviewing the record only. The court is not to consider any new or different testimony. The court has to review the record that was before the hearing officer and determine whether or not that decision was supported by law and whether or not it was supported by substantial material and competent evidence and was not otherwise arbitrary or capricious. In reviewing the hearing officer's decision, the court finds that there was proper application of the law in this case. So I don't view this as a de novo review. This really is a question of the factual sufficiency of the evidence to support the hearing officer's decision. And in that kind of review, the court is, because it's not de novo, I'm not substituting my judgment for that of the hearing officer. My decision in this case isn't about what I would have done had I been the fact finder. And it's not my job to second guess. My job is, again, to determine whether or not the decision was supported by the evidence. I also know, because I think credibility is a big issue in this case, that reviewing courts generally allow a substantial degree of deference to a fact finder's determination of credibility. They're the ones that hear the testimony and the evidence, and I'm just reviewing what I read written words on a page, which can have a different effect. So looking at this in that light, and when I read the hearing officer's decision, it was apparent to me in my reading of that, and I agree with the prosecutor in what he said, which is it was much more my view that the hearing officer's issue was with the credibility of the evidence rather than the length of sobriety. And I tend to agree with Mr. Sheffalo that, you know, it's been 16, 17 years since these discrepancies, to the extent they are discrepancies, occurred. And that's much more relevant in terms of the requirements for the period of sobriety if it had been more recent and we were trying to make that 1 year determination. And it's after this amount of passage of time between now and when those discrepancies occurred, it's not necessarily material to that 1 year standard. So I don't disagree with Mr. Sheffalo's point on that. But I do think that the discrepancies are relevant to credibility. And that's a different area of relevance than their relevance to the length of sobriety in this case. And so why is credibility important in this case? And why are those discrepancies relevant to credibility? Well, number one, it goes to whether or not the hearing officer found Mr. Sharkowski believable in his testimony about his substance use then. And if the hearing officer didn't feel he was credible about that, then it calls into question whether or not the hearing officer believes that he's credible about what he says he's doing now. And the petitioner's testimony is a big part of the evidence in this case, both as to what happened then, but also what happened during the intervening years and what's happening now. And so if he has credibility problems, or the hearing officer finds that he has credibility problems, then that affects not just those discrepancies back in 2008 or 2009, but the believability of the testimony about his substance use now and his circumstances generally now. It's important in looking at the evaluation by Mr. Green, the substance abuse evaluation. As we all know, so much of that information comes from self-reported information. And so again, if the hearing officer finds that Mr. Sharkowski isn't credible, then it calls into question the information he provided to that evaluator. And then of course, it calls into question the conclusions that the evaluator reaches based on that information. In terms of the letters that were submitted, the Secretary of State requires submission of letters from a cross-section of society, from all areas of a petitioner's life. And I looked at the letters. There are a couple from individuals who are, there are two, I believe, from individuals who are not related necessarily to Mr. Sharkowski, but at least three of those were, you know, from his mother, from his fiance, and from his daughter, all of whom are people who have a personal interest because they care about Mr. Sharkowski and want to see him get his license back, but also based on the testimony, may have, you know, an interest in him having his license because it would make their lives easier to some degree or another as well, or allow him to help them to a greater degree. So, you know, I think the potential that some of those letters didn't have the impact on the hearing officer that was hoped for, I think could be a factor as well. So when we look at what are the discrepancies, looking at Mr. Sharkowski's testimony at the hearing, his description of the accident itself, I mean, in my view, again, I think was a little bit problematic. There were discrepancies in his description. In my view, it seemed to be a lack of full accountability there. He talks about the glare being an issue. He dropped his phone. You know, he was going up a hill. The biker, you know, may have been in the roadway a little bit. There's a lot of reasons that Mr. Sharkowski gives for the accident itself, other than he just wasn't paying attention and wasn't doing what he was supposed to do while in control of that vehicle and looking out for other people on the roadway, both drivers and bikers. And I think that's problematic and a discrepancy that has an effect because I think from the hearing officer's perspective, that could call into question what Mr. Sharkowski would do if he's granted his license going forward. will he be taking full responsibility for his own actions on the road and appropriately looking out for other individuals? Or if another accident happened, is it going to be the fault or the cause of some other factor other than his driving? And I don't know, that's a problem, I think. In terms of the substance use, there were clearly discrepancies in whether or not he used methamphetamine at all, the date of his last use, the degree and extent of alcohol use, I think, was not clear based on his testimony. And of course, the date of the last use, I don't think was clear. And all of that goes, of course, to the issue of whether any substance abuse problem, even if it wasn't related to the accident in this case, is under control and likely to remain under control. And that goes to whether or not Mr. Sharkowski would safely operate a vehicle going forward. And looking at all of those discrepancies in his testimony as a whole, and applying the court's standard of review here, which is just, again, to determine whether the hearing officer's decision was supported by evidence, I find that it was supported by sufficient evidence. So for the reasons I've stated, the court is going to deny the appeal. Mr. Shefflow, I know you did submit an order granting it. I would ask that you submit an order either with a stipulation as to form from Mr. Ziegler or under the 7-day rule, so that we have a final order in place to the extent that Mr. Sharkowski wants to pursue other appellate relief.
I can do that. Thank you, Trevor.
Okay, thank you. That's all I have for this hearing today, and all parties are free to disconnect at this time.
Thank you.